Hello everyone, my name is Michele Ubertone. I am an assistant professor in legal theory and philosophy of law at the University of Maastricht, at the European Law School. And today I'm going to talk to you about whether disgust can predict legal decisions. This is the second part of a talk that was introduced by Giuseppe Rocchè. In the first part of this lecture, Giuseppe told you about Haidt's theory of moral psychology. In this part, I will try to present an experimental protocol that Giuseppe and I have developed to try to apply this methodology, this theory, to legal reasoning as opposed to moral reasoning. So, as Giuseppe said, the model presented by Haidt, the social intuitionist model, can be summarized as you can see in this slide. So, according to the social intuitionist model, we do not reach conclusions in moral cases based on deliberate, conscious reflections of the reasons for deciding one way or in another way. Our reasoning is just an ex post facto rationalization of a conclusion that we reach in an intuitive way and unconscious way. So we can contrast this model with the rationalist model. According to the rationalist model, there is an eliciting situation. In the legal scenario, this should be the facts of a case. Then we should reason based on the fact and based on the law, develop some legal reasoning, and this legal reasoning will lead us to a judgment, a decision of whether we find a violation or we don't find it. Well, if we have to apply this model to legal reasoning, then it would mean that things work differently. So we react to the eliciting situation, to the facts of the case, intuitively, and this intuition is just triggered by our emotions and is triggered unconsciously. This produces in us a judgment, the decision, whether there was a violation or there was not a violation, and then we ex post facto rationalize, we look up the law to find reasons to say that there was a violation or there was not a violation. So our question is, can Johanathan Haidt's theory be applied to law in the way that I have tried to explain in the previous slide? This would be very important. If we actually found this phenomenon to be relevant for law, this would be relevant for a lot of debates that exist in legal theory. In particular, there is this idea in legal theory that accepting the authority of the law means to accept and be motivated by a special type of reasons. So legal reasoning can be defined as the type of reasoning that is performed based on that particular type of reason. According to Joseph Raz, legal reasons are exclusionary in nature. This means that when we accept to decide a case on the basis of the law, we are, by the same token, accepting not to decide it according to reasons that are excluded or considered irrelevant by the law itself. So, in a sense, legal reasoning is reasoning that excludes various kinds of consideration, including moral considerations. The problem that our experiment would tackle is whether we are actually able to do that. Can we blind ourselves and disregard morally relevant but legally irrelevant factors in this way when we take legal decisions. Another more colorful way to put it would be this: can we switch on our legal brain and switch off our moral brain at will, like Raz's model, Joseph Raz's theory, seems to suggest? Well, to understand this, we have to answer this question: is legal reasoning affected by the phenomenon Haidt describes? It's interesting to notice that whatever the answer to this question turns out to be, the result would be meaningful and interesting for legal theory. If legal reasoning is affected by this type of distortion that exists in moral reasoning, then this will have groundbreaking effects on our conception of the rule of law. This would mean, in a sense, that the very idea of legality is predicated on abilities that humans don't fully possess. So in a way, the regulatory ideal of the rule of law would seem somehow unattainable. The second option, the idea if legal reasoning turns out not to be affected by this phenomenon, then this would also be very interesting, because it would be relevant for a very old debate in legal theory, which has to do with the question whether law and morality are necessarily connected, whether legal reasoning is a type of moral reasoning. If legal reasoning is not affected by a psychological phenomenon that characterizes all other types of moral reasoning, then this would suggest that moral judgments and legalistic applications of rules may be two distinct psychological natural kinds, two different psychological mechanisms. And another way to put it would be this: we can make this argument in a deductive way, using the structure of a modus tollens. The major premise of this modus tollens would be: if legal reasoning is a type of moral reasoning, then it occurs ex post facto, according to Haidt's scheme that we saw in one of the first slides. But legal reasoning turns out not to occur ex post facto. Well, then the conclusion is that legal reasoning is not a type of moral reasoning. This would be an interesting way to tackle experimentally a question that has always been discussed a priori by legal philosophers. Let's now try to define what is the hypothesis that we want to test, the most important hypothesis we want to test with our experiment. The hypothesis is this: legal judgments are intuitive and do not necessarily depend causally on the reasons with which we justify them in good faith. This means that the reasons we provide to justify our conclusions are not the causes that make us state those conclusions. The reasons we provide are actually ex post facto rationalizations. The way in which we want to test this hypothesis is through testing two other, more specific hypotheses. The first one is that disgust has a causal effect on legal judgment. Disgusting but legally irrelevant features of a person or of a person's behavior will make decision makers more inclined to attribute legal responsibility to that person or for that behavior. The second hypothesis is that if the judgment is caused by disgust, subjects will be inclined to justify that judgment with reasons other than disgust. If there are no available reasons, they will either remain speechless, dumbfounded, to use Haidt's terminology, or make up reasons that are actually not supported by the text of the case. The way in which we want to test our hypothesis is through what we can call a twin case methodology. We present two groups with two sets of cases, and these cases are twins in the sense that they are almost identical except for one important aspect. In the experimental group, the conduits described have some additional legally relevant details that are not present in the control group. So the cases presented to the experimental group describe conduits containing legally irrelevant details that we have introduced for the sole purpose of arousing disgust in the subjects. The cases presented to the control group are identical in all legally relevant aspects, but lack these disgusting details. We expect subjects who show some sensitivity to disgust in Haidt's moral cases that are presented in a second part of our questionnaire to also be more prone than others to condemn in legal cases, the first part of our questionnaire. Then there is a third part of the questionnaire where subjects are asked, actually a questionnaire, where subjects are asked to indicate the legal reasons for their verdict. So let's make an example of these twin cases. Okay, so this is an example of a case that is presented to the control group, an example of non-disgusting case. Robert looks after his old, blind, and disabled mother. The son resents his mother because he believes she should bequeath, I don't know how to pronounce this word, more to him and less to his sister Anna. Out of rage, he decides to feed her seafood for an extended period of time, passing them off as pasta in broth. The mother has always found seafood disgusting, but now she does not notice anything and does not suffer any negative health consequences. When Anna hears about this, she sues her brother on her mother's behalf for damages. Should Robert be condemned to pay compensation? In the experimental group, the case is just the same, except for the underlying parts of the text. So, the seafood is substituted with flower worms and various insects. So, in the first case, the mother eats something that she considered disgusting, even if she does not realize. And so the food is something disgusting for the victim, whereas in the experimental group, the food is something presumably disgusting for the respondent, for the subjects that will decide the case. So we have gathered some data, and these data are suggestive that our hypothesis is confirmed. Of course, this is not, it's an ongoing project, and so we cannot claim it yet. This presentation is just aimed at presenting our methodology. So what are some possible problems with this methodology? I'll list them before wrapping up and finishing my presentation. So the first problem, first objection that can be raised is that how can we tell that the disgusting cases are actually disgusting? Well, here what we want to do is to have the cases tested by third parties. So we are testing the material used for the experiment, presenting them to a different group who must be asked to rate the cases based on how much they are disgusted by them. Another problem. Why do we think that it's so obvious that the fact that the behavior is disgusting is legally irrelevant? Well, if it weren't considered legally irrelevant by the subject, they should state it in the open responses. The open responses should explain us why not. If our second hypothesis is confirmed, subject should not mention disgust as a reason for the decision. Another problem. Are legal cases really alike in all other relevant respects, except for the disgust? How can we tell that the cases are actually equivalent? So, like, except for the fact that insects, for instance, are more disgusting than seafood, how can we tell that the situation is legally the same? So this is an assumption in our twin case methodology, and we want to test this assumption by having the legal equivalence of the cases accessed also here by third parties. In this case, the group who will test this assumption will be composed by members who display two features. They should show low sensitivity to the moral foundation of sanctity and degradation. So we will have to test them with the questions taken from Haidt himself. And also we should also make sure that they are legal experts. How can we diagnose legal dumbfounding? Well, there would be two ways. One would be the graphical equivalent of remaining speechless, namely leaving the question blank. So we will consider the subject in the experimental group who show the leave the question blank will be more than the subjects in the control group. And the second way is that subjects in the control group should mention details that are not present in the case, that are not justified by the text of the case. Two words about the ways in which this research could be developed in the future, especially if our hypotheses were confirmed. If we found that disgust can actually predict legal decision making, a question that may be asked is whether this distortion of the judgment happens because subjects have a different assessment of the question of law, so they perceive differently the meaning of the applicable law, or they have a different perception of the facts of the case, or maybe neither of the two. They have some kind of holistic assessment of the case. Another question is whether it is relevant that the disgusting features, the disgust in the subject is caused by details that are part of the case itself. Haidt made some experiments where this was not the case, where the disgust was aroused in subjects, not with disgusting elements in the case, but just by having them decided, for instance, in a dirty environment, on a sticky table. So an interesting question would be whether this also applies to the legal scenario. And finally, and this is probably the most interesting question, is whether legal expertise has some effect, has some debiasing effect, or maybe the opposite effect in deciding cases. So does expertise make people more or less affected by disgust? All of these questions are still to be tested and answered, and we hope we'll be able to do it in the following years. And thank you very much for your attention.